Case number D467098, Dziedzic versus Dziedzic. Counsel, please state your names and bar numbers for the record.
Denise Gentili, bar number 4271 on behalf of Amy Hanley.
Your Honor, Mario Fanu, 11376 on behalf of Amy Hanley.
And are you substituting in for Ms. Gentili?
Your Honor, I am confirming as counsel today in place of Ms. Gentili.
Do it as a substitution then. Or are you going to stay in the case?
No, he's stepping in.
Okay, just do a formal so it's of record.
I will file a notice of appearance.
Okay.
How's that?
Yeah, because I have to do the withdrawal under the unbundled deal. Okay,
that's
I'll do
fine.
that. Perfect.
Thank you, Your Honor. Patricia Vaccarino, bar number 5157. I'm still present and appearing for the
Okay,
designation.
this is on the plaintiff's motion to modify custody to award primary physical custody of the mother, to modify child support for an order to show cause, for sanctions, for compensatory makeup, fees, and costs. Ms. Vaccarino, where are the kids?
Oh, pursuant to your last court order, the children are in Mike's custody.
Right now, they're in her. We're picking them up.
No, that wasn't the question I
Where are
asked.
the kids? Right now, immediately, right now?
Are they here in Nevada?
Yes. Oh, I thought that
And
was true.
for the record, are they registered for school in Nevada?
Yes.
Is your client moving to Utah?
No, and he wrote in his letter attached to Exhibit 1 that was a consideration.
You mean the one that I didn't read?
It's fine, Your Honor. Yes.
It was served on you on July 9th, and it's
I understand.
34 days later that it was filed.
And we tried to continue this matter under local court rule. You could remove this legally, and there's not the prima facie case here, but if
Actually,
you
I
wanted
think there is.
And then, I'd like to have the findings under the Friedman case. I could possibly do a writ. I know you're going to say, welcome to do what you want. If you're the one who said close this down, 4 or 5 hearings, and now you're saying let's blow it back up on the Rooney standard we confidently believe has not been met, then I'd like to hear your findings of fact and the conclusion of law.
Which we will do at the time of the evidentiary hearing.
And Judge,
Rooney has to be decided
wanna,
today, Your Honor.
Well, I find there is sufficient material in the motion to survive the Rooney standard. Okay?
So war is back on.
the reason, the only
Remember, you
reason.
apply the Rooney standard. I want to make something perfectly clear. You apply the Rooney standard based on the bare bones allegations. If the bare bones allegations rise to the level of evidence to be deduced, then the Rooney standard has been met. You may not like the motion, but I have to look at it based on the allegations. Now, it's certainly up to the plaintiff at a time of an evidentiary hearing to present her case in chief. If, in fact, her case in chief proves to be insufficient, then you may have grounds for a motion for judgment on the record. But right now, it does meet the Rooney standard. So your argument, which may be contained in something I haven't read because it wasn't properly filed or served, is that then I disagree with you respectfully, counsel, that the Rooney standard has been met. I don't see any point in sending these parties to mediation. I think that ship sailed a long time ago. So I'm going to set an evidentiary hearing. What I'm going to give you is a Monday in October. It's the best I can do right now. In the meantime,
we need more time.
What?
My client.
Can I please speak? I wasn't done. In the meantime, I started on the meantime before I got interrupted. In the meantime, the minor children are to remain in the state of Nevada, and specifically in Clark County, pending further court order.
Your Honor, what is the reason for restriction my client's right under the First Amendment of the Constitution to possibly have a vacation with his children? Why would you restrict those children to going to
Till
prom?
I know whether or not.
Come on, Your Honor. There's no basis for constitutional restriction of his right to travel, even intra or interstate with
Take
the
me
children.
up on a writ then.
Your Honor, I can't,
Take me up on a
the
writ.
attitude you have in
I
this
don't
case and other
agree,
cases
and
with
I
me,
dislike.
you disagree with him. There's
Counsel,
no evidence that he's moving out of state.
You have, in this case, been repeatedly disrespectful to this court. I am not going to tolerate it any further. If you do not like my decision, you are free to take it up on a writ. But in the meantime, this is my order from today.
If I may, Your Honor, he has a girlfriend that lived in Utah. I know she just might have
Right.
sold her home.
We just moved.
Sometimes they travel to Utah. You're in Nevada
We just
now.
moved everything out. It's all in my house now.
So to restrict him to
We are-
only, wait a minute, Clark County, within the, not to leave the county, without sufficient facts alleged that he's some type of flight risk, you're just basically limiting his right. The same thing on her side. You don't say the plaintiff she can't leave Clark County. This has been a very, if you said, off the rails.
Is it my turn to explain that?
Your Honor,
is it my
with
turn?
respect, if you would make findings as to why you think
I
there's such
don't
a
make
severe-
findings until I've heard evidence.
And you said you may if she doesn't prove a sufficient case under the Ellis standard. And as Rivero said, we're not supposed to invite frivolous motions, or we're supposed to have the public
isn't a
policy of
frivolous
stability.
motion, counsel.
You don't think so?
No, I don't.
It seems like you're maybe. I know you get mad at me saying disrespectful.
I'm not mad at you.
The
I
record
dislike
is,
the disrespect.
It seems like
if you
prejudgment.
don't agree, then you're free to take me up
I don't
on a writ.
understand the legal
And by
reason.
the way, just for the record, it is the plaintiff who has weekend visitation. It is the kids who are going to school. This does not disrupt your client from going to see his girlfriend in Utah.
Your Honor, I'm just saying I'm not understanding, and that's why I want to clearly, because it's a very restrictive order when we tell a parent they can't leave the county.
I suppose you don't realize that you got a gift. Your client got a gift.
A gift?
Oh, yeah. I could have granted the motion as unopposed.
Which would be a severe abuse of your discretion to do what's in the best interest of children.
Well, then you should have filed a timely
Your
opposition.
Honor, and if this is about my timeliness of filing, you told us to work this out and
So,
negotiate
you know,
the
I
financial
find
issues.
that really
fine.
puzzling.
My
because,
client had to borrow
no,
money to retain
counsel,
me again, and he
counsel,
will be without counsel
counsel.
if you shove an evidentiary hearing down his throat in October.
Are you done?
If you let me make
Are
my
you
record,
done?
then I'll be done.
Are you done? Okay. Now, I can think of any number of occasions when you took the position that I should not consider an opposition that was untimely. So I'm going to tell you right now, I'm going to apply, this is why it's a gift. Well, I'm not going to read your opposition. You're certainly free to oppose at an evidentiary hearing. I'm going to allow you to do so, because I'm going to make a best interest determination, and I'm going to be making a material change of circumstances affecting children determination. I haven't made that yet, but on its face, the motion has merit. It may well turn out to be much ado about nothing. So, we will set an evidentiary hearing. I'm going to give you a Monday in October all day. I hope we only need the one day.
If I may, Your Honor, my
May
client
I be-
has his vacation.
I believe it's plaintiff's motion, and I
And
can...
if I may be
I
heard on
can-
his vacation
No.
that
All
starts
right,
this Friday.
please.
I
Mr.
can
Panu
wait.
has respectfully asked to speak, that it's his motion. You're allowed to do so.
I can wait if the court would like. I just wanted to make a couple of representations. If Ms. Vaccarino wants to finish where she was going, I can wait.
I want to hear from you, Mr. Panu.
I won't come in here and represent to you that I'm the most up-to-date on things. I was retained yesterday, but I will say I stayed up close to midnight reviewing and
Oh, there's a lot here.
and understanding. And I'll say this. The facts are, there's a lot. They're specific. The law and procedure, if
I'm
we
going to
look back,
suggest to you
well,
that you not only read everything in the file, you watch every video.
I will. There's a couple of things I wanted to highlight based on that, and that is the parties have been through a tremendous expense. Let's say that. Let's acknowledge that if we don't have to look back far to see the complexity of this case, and that's not a complaint, that is just, it's a fact of the developments in this case, the procedure, and how we got here. The case has a tortured past, and I don't think that's saying a lot. What I would ask for at the end of the day, Your Honor, we're looking at some very important issues. Mr. Is it Dziedzic?
Dziedzic.
Mr. Dziedzic's fundamental right to parent his child, and Ms. Hanley's fundamental right to parent these children. I guess that's what we're balancing, and sure, that has to be done in the best interest. But to a greater or lesser extent, and this is policy, and you've heard me argue this before, but courts are here to, I think, manage and triage, but not babysit. They shouldn't be babysitting cases, and I think you subscribe to that. I mean, I've seen the way you've handled cases in general, and I appreciate that, and there's a concern for the expense, and Ms. Vaccarino just expressed a concern for the expense. I'm not asking you not to set an evidentiary. I appreciate that, and I think October 9th would be fantastic. What I'm
I
asking...
haven't come up with the October, have we?
Okay, whatever date. But my issue is not with an evidentiary. What I would ask for, Your Honor, is you add one more piece to this order today. I would ask you that under 125-510, as you know, during the pendency, making an order for custody, that you consider the following. You give the parties an order for joint physical custody. I don't know that's asking a lot, but...
It's not how I roll, you know that.
Well, here's the
I
thing.
don't disrupt orders until I take evidence, and this is a plea that, frankly, Ms. Gentile has made a couple of times as well, and I'm bound by a prior order. I'm bound by a prior judgment. It takes the Ellis standard to vary that, and I don't know that without the taking of evidence that it's met.
I would say
I
this.
will consider if there's been a withholding, and again, that's going to be part of the case, make-up time as well. But I'm not there yet. I'm just not.
And I don't mean to be presumptuous in what I'm about to say, but I feel like having considered everything that is on file, with the exception of Ms. Vaccarino's or Mr. Dziedzic's opposition that was filed late. I haven't looked at that yet. That wasn't on file last night when I looked. This is a case that, at a minimum, is deserving of joint physical custody. And knowing that we're going in that direction, I'm not asking you not to follow through with an evidentiary, but you have said that there's serious questions with the validity of prior orders, how we obtained initially the decree.
I never said there was concerns about the validity. What I said was I was concerned how we got from one point to the next.
Okay, I would say semantics, but I agree with you on that as well. The problem's how we got from A to B, no doubt about it.
And some of them, as I observed to
So-
Ms. Gentile, were in fact created by your own client.
Oh, fair enough, but we are now in the position, unfortunately, of this disingenuous position that capitalizes on perhaps a defective order. We can call it however we want, improperly got from one to another, but
And this applies to everybody in this room. My goal is, and always has been, to try to make the lives of children livable, so they're not tortured, so they grow up healthy. Okay? It's a best interest standard. Now, whenever we inherit a case, we take the case we have. I have to temper what I do with getting there in a legal and rules-oriented fashion. So, you know, I've been saying to people the past few months a lot, there are times I have to make decisions that were I able to go on sympathy, I would not make. But I'm not ruled by sympathy. I cannot be ruled by sympathy. I have to be ruled by the rule of law. That's my boss. I say the law and the Constitution are my bosses. And I have to follow that path. So for me to vary based on the argument, and I think it is sympathy, and I'm not unsympathetic, I think would be violating everything that I hold dear in terms of the law. And I can't do that. So I appreciate your impassioned argument.
I respect your position. I will just say, and I will live with it, no doubt about it, I disagree that there aren't some legal bases, because I don't want this court or any court to make a decision on sympathy. But we can agree to disagree on that and move forward. There is one pressing issue if we leave today as things currently are, and that is school, and I would ask the court how you think we should proceed. School begins August 25th. The children are currently enrolled in Judith Steele, first, second, and third grade.
Right.
The issue is
Isn't one of them going to kindergarten too?
He's starting first.
First, second, third grade, and then the new one on the way in 6 weeks, but certainly not the subject of this litigation. But
No, wait.
the issue is...
No, isn't Devin starting in kindergarten or first grade?
First grade.
Your Honor.
First,
wow.
we have a first, second, and third grader.
Okay.
And the same school they are enrolled, Your Honor, we are confirming that.
Okay.
The issue is that was a unilateral... As you see laid out in the motion,
I think there was an order
The host
allowing
of
the
legal-
defendant to register the kids in his school district.
If I may speak on that,
No,
Your Honor.
just
Okay.
a minute. I want to let Mr. Fanu
All right,
finish.
okay.
certainly I'm not aware of that. Enlighten
This
me.
is not an easy case. There
It's
are
not, but
so many nuances here, I can't even
My
begin
concern
to.
is that if we come back, whether it's late August, October, November, we are certainly past the point of school, and we are of the position that's been a unilateral decision. As you see laid out in the motion, there is a tortured history of violations of not just physical custody or visitation, pardon me, but legal custody. And I understand.
And that's going to be part of your...
I understand you have to take evidence, and I get that, and that's not today. But how do we address the fact that by the time we come back, there are the children left in Judas Steel, and that clearly was not the product of a co-parenting
There
decision?
is an unfortunate trend here. People move all the time. And kids are compelled to change schools all the time. Again, this is not a case where I can rule on what I call my druthers. But I have to honor the last order, and the children are going to remain. I would rather they can start school. I mean, they've been through plenty with these two parents. They have. A lot. I think it helps for them to start school where their friends are. If I change my decision later, be that as it may. But I think right now, for the sake of those kids and their well-being, I don't want to disrupt them, so I'm ordering that they remain in the school for which the defendant zoned. It is possible. I haven't gotten that far yet, because I want to see the evidence. This is hotly contested, the evidence itself. I want to see the evidence, so I rule, and I know I'm doing the best I can for these kids, and I'm following the law, and I'm not there yet, so I have to deny that request. Ms. Vaccarino, did you want to say anything?
Thank you, Your Honor.
Please keep it brief, though.
Yes, thank you, Your Honor. My understanding of the school issue is under joint legal custody. They remain enrolled in the present school, absent a further order of the court. They have been in that school all last year, and my client got not one letter from her asking about or inquiring. But we would ask, Your Honor, that you make this an affirmative order. Hotly contested, and this is in the best interest of the children and co-parenting to add to joint legal custody, that both of them are required, before running to attorneys, to write, maybe even our family wizard, and that would benefit her since he has primary. But even at least if we start with email on each and every issue of concern in advance, so that you don't get in court.
Wait to see the proposed new rule.
Okay. But I'm saying, can you please, and obviously, I know you helped write those proposed new rules, and what are they meant to do? To avoid the extensive cost of a lot of
I
that.
understand what you're saying.
And that's all I'm saying, Your Honor. And I'm not meaning to be disrespectful of this court. My client still hasn't paid me for today's hearing, and he was thinking of coming in pro per today. And this is more a financial issue of concern. And like you said, these children deserve to have normalcy. And you've said 3 hearings ago they won't until this gets over with. So.
And that's why I'm having an evidentiary
And I
hearing.
ask you, my client needs, he asked me, he needs at least till December to save up the funds to even pay me if I stay on this case. If I don't, that he will not have equal access to justice. And this is with a mom that has paid 0 child support the last year, and that is a double whammy because he's 100% supporting the children.
Okay.
That's all I'm saying is he's tied and he
I
doesn't have,
understand
I know you
that
said this in another case.
No. I'm reconsidering the October date based on
Thank
what you said.
And as to the vacation issue, because again, no foul play, you said that I don't disrupt orders until I take evidence, or if you have obviously a sua sponte huge reason. My client told the plaintiff in February or March that he had a week-long vacation plan that starts this Friday. He took off of work for it, he planned for it, he and his girlfriend paid for it a year in advance. It's a cruise, and it will go to Laguna, it will go down to Ensenada and back. So there's no passport, no issue. There has been no flight risk concerns, so we're asking that you take back that
I
restricted
understand
order.
that.
I appreciate
My order had more to do with Utah than it did.
No, and he's
I want
not
Your Honor to know
relocating
we
the
have
children.
no issue with this cruise. In other words, I know you ordered, but
Done.
we're okay
Thank you.
with these children going on this cruise. I want you to know that. Or if they were going to go back to Utah, she probably would agree that they can have a vacation there. But the issue is that he comes back, that we end this game of I'm going to stay in Utah.
She sold her house in Utah. So the point
Okay,
is-
I would just add one more thing, Your Honor. I know we're running out of time. What is Your Honor looking to. If you would just indulge us with a little bit of what you're looking for that might change this case to joint physical custody. If there are issues of expense, the people ought to be reasonable. Potentially, we settle this case in light of the evidentiary. Can you shed some light on what you're seeing or how you're seeing things now?
The things that were in the motion that concerned me, and again, I don't want to tie my own hands, okay? But of the concerns were the issue of withholding, the issues of joint legal custody, the issue of Utah. These are those issues that would, if proven, any or all of them might sway me on a best interest standard that the parties should have a more equal timeshare. But I don't want to tie myself up. Things may come up in the hearing that I'm not anticipating that might be in the penumbra of what I was talking about.
You say best interest, but that would be Truax, and we are under the LS standard in this case. I just want to make that clear. I know you are aware of that, and you know that. We're going for
I think I cited Ellis a few moments ago.
No, I know, but you just keep saying under best interest, but you are under a substantial change, and
I understand
we will be able
that.
to explain
I
all that.
consider withholding a child a substantial change in circumstances.
Okay, and you're right. And when you read our paperwork, you'll see that she has not been honest
Counsel,
with the
you've
court.
gotten a lot of
Absolutely.
leeway to argue this
Okay,
motion.
then all I'd ask for is if you want me to renotice our.
Can we agree to a December date?
I don't think that's an issue. That's fine.
Okay, let's find it. Do we have anything in December on a Monday?
Yes, we have the 1st or the 8th.
Pick one, 1st or 8th. I'm going to allow you to pick one.
I like the first two.
The later, the better, Your Honor.
The 8th is my mother's birthday, if that would
The
be left
22nd.
open.
The 22nd would be fine, Your Honor.
You have the 22nd? Okay, let's go with the 22nd.
That's right before
Well,
Christmas.
It doesn't really matter. I mean, if you can't,
Is anybody going away for Christmas vacation or anything?
I was planning on it, but I'll go after. It's over.
Usually.
What day is that? A Monday?
22nd is a Monday, but it's leading right into the...
Let's take the 22nd.
Are you thinking a one-day, half-day?
Neither.
Probably
I'm
one day.
hoping we can, it's going to be a full day, and I'm hoping we can be done. I'm not entirely optimistic, but I'm going to try really hard to push it to a day. I think there are going to be limited numbers of witnesses, so that will help.
You want to? Would it make sense for you to stagger on the 1st, December 1st, and the 22nd in the event there's a spillover? At least.
I don't. The time necessary for my client, the time to do
I'm
discovery.
going to go with the 22nd.
And also,
I
it just costs so much money to come back and come back.
You can't argue.
You said
You can't argue money, but we have lots of discovery to. First of all, there's not
transport.
really a lot of discovery to be done on the issues we already know.
But,
I think it's a credibility issue for Your Honor. Who do you believe, frankly?
well, it's more than that. I mean, it goes to what's been going on, but as a practical matter, I try to issue orders that allow people to keep their attorneys. So we're going with the 22nd.
Appreciate it.
Okay.
That means pre-hearing briefs, citing applicable law, applying the law to the facts of the case by December 15th. Discovery will close on December 8th. What that means until the new rules go into effect, which is a while off, is that the close of discovery means that any written discovery to be served by one party upon the other must be served at least a week and a month prior to the close of discovery, so discovery really ends by that date.
Can we get a clarification or a reaffirmation of your order that FDFs file? I know my client didn't get one filed either. I'm not sure why. I will make sure that gets
I want
done.
the parties to file their FDFs no later than the close of discovery.
I'm going to
That would mean
renotice our
updated.
financial motions. So,
I
and you did
was-
order the last hearing. We're going to have to renotice the motion for arrears and to compel child support.
No, that's different. That's different. I just mean, can we have an FDF on file in
Yeah.
the next 7 days,
Yes.
10 days? That's
Yeah,
all I
fine,
need.
file it. And by the way,
so
do y'all
stipulated.
have the new form that's going to
gave
be
it.
obsolete in a few weeks?
Again?
There was a technical error, I swear.
okay.
There was a technical error, and the Supreme Court adopted the wrong
We
one.
gave you that. We
But
provided to
it's,
us earlier,
right now,
and he
it's the
has
one
it.
that's in effect.
That's the one I gave you.
So next 7 days, Ms. Vaccarino, is that okay?
7 business judicial days. How about that?
Just
It is
7 days.
mostly,
10.
there's like 3 differences that are very
10
minor.
days is fine.
10 days.
10 days.
FDFs in 10
Both
days.
parties file. And they're to include, they both have issues of possibly cohabitant income or contribution.
Well, that's
Under
ED's
5.32.
always applicable.
Okay, thank you.
And, Ms. Vaccarino, you do have the current form, which is the penultimate form.
You gave it to me 2 weeks ago.
Yeah, that's
so
the
if
penultimate.
That's the penultimate, then
Are you saying you want the current form used or
Yeah, you
the
can use
up and
this
coming
one.
form?
You can do this one.
Okay.
The changes are important, but not, substantial in the context of this case. And unless there's an income-producing asset, I'm not going to require the parties to complete the asset or debt portion, save and except for an income-producing asset. Mr. Fanu will have the pleasure of preparing from today.
Can you give us a return date? You said, we talked about this last year on July 15th too, to get the child support properly set, and I did file a counter motion formally. I was hoping Denise and I could work it out. We weren't able to.
I'm going to do this.
I can renotice
You
it.
and
but I
Mr.
need-
Fanu are going to sit down after you've received it and try to do math. If for some reason you can't reach an agreement, then I suppose you'll have to get it in front of me. I'm trying to minimize the number of hearings, in part because I recognize that neither party is fabulously wealthy.
So I can either do a notice of motion today for the counter motion, or I can
Have a
respectfully ask
friendly
you,
chat with Mr.
can I
Fanu.
have a 6-week return instead of having to do more paperwork?
No, you can have
Thank
a
you, I'll
friendly chat
renotice it.
because
I will
it's
have
not-
the conversation, but I know I'll have to renotice it, not because of the attorney, but because of the fact that when you pay zero for 12 months, you can't expect to get a dime the
Work
next
it
month.
out. Please.
You admonished the plaintiff last time to pay some support. She's paid zero.
Work it out.
It's easier said than done in certain cases.
Mr. Fanu has been listening to you.
Thank you, Your Honor. I will renotice the counter motion, or I'll notice it instead of filing a whole new
Thank you.
document. Thank you for your time.